Welcome once again to Lehto's Law. Here's Steve Lehto.
I think I did a story about this originally when the accident happened and the jury returned its verdict. But now we've got a story about the appeal. And this is a big story involving truckers. So I got a lot of people who sent this to me, and a lot of people in my audience are truck drivers. And I mentioned it as a group. Truck drivers get my respect because if you walk through a store, anything you see in there was at one point or another traveling by truck. Without truck drivers, our country would grind to a halt. So the headline here is Texas Appeals Court upholds a $100 million judgment against Werner. It's from Yahoo Finance, and John Kingston wrote it. Truckload carrier Werner Enterprises has lost a key round in the appeal of a jury decision that saddled it with now more than $100 million judgment as a result of an accident in 2014 that resulted in the death of a child and serious injuries to family members. Now, Werner is going to appeal this ruling. In a statement, the executive VP and chief legal officer said, Werner is disappointed with the Court of Appeals decision, and we plan to seek relief with the Texas Supreme Court. In a split decision by Texas's 14th Court of Appeals issued last week, the judges backed the decision handed down in Harris County in May of 2018. That judgment was then valued at $92 million, but has since grown because of interest that accrues after a judgment is entered. The appeal went straight to an en banc hearing at the 14th Court of Appeals after a controversial move in 2021 to skip over the usual three-judge appeals panel. So there's a group of judges in a pool, and when you file an appeal, traditionally they just grab three at random and say, you three are hearing this case. If you want to appeal that, you can often say, you know something, we don't like what these three did. We want the entire panel to hear our case. And they apparently skipped the first step, and they just said, look, this case is so important, it's involving almost $100 million. Can we get the entire panel to hear it? And they agreed to do it. So Werner already has taken financial hits from the verdict, according to its annual 10-K report filed with the SEC earlier this year. But its filing makes clear it is not on the hook for the full amount of the judgment if it makes it through any further appeals. Werner said in that filing that its maximum liability is $10 million plus interest, pre-judgment, and post. It also said in the filing that it already has recorded liabilities of $34 million and $28 million for the two previous years, respectively. Werner in the filing also said it had recorded a $79 million receivable from the insurance company and an offsetting liability in the same amount. So it looks like insurance might be covering some of this. But what happened on the day of the wreck, which was just after Christmas 2014, I-20 near Odessa was hit by freezing rain and black ice. A car driven by Trey Salinas, transporting a woman named Jennifer Blake and her three children, crossed the median and hit a truck head-on driven by a Werner driver, who is also a defendant in the case along with Werner. So the allegation is that the vehicle that had the victims in it crossed over the median and hit the other truck head-on. Now, one of the children in that vehicle was killed, another was left a quadriplegic, and a third child had significant but non-life-threatening injuries, and then Blake had physical injuries and mild brain injuries. And so Blake is one of the people in that vehicle, driven by Trey Salinas. Although the lower court found most of the liability fell on Werner and the driver of the truck, there was some blame assessed against the driver of the vehicle that crossed the median. But here's where it gets funny, is the math. And the jury actually broke it down by percentages and said that 70% of the blame was the truck drivers, 14% was the driver of the truck, and 16% was on the driver of the vehicle that crossed the median. And most people hearing these facts would go, wait a second. Somebody's in a vehicle on an icy day, and they cross the median and run head-on into a truck, and that's 70% the trucking company's fault and 14% the driver of that truck's fault? That does seem a little off mathematically, but the Court of Appeals decision to uphold the lower court decision was not unanimous. There were dissents on some of the findings, even by judges who agreed with other parts of the decision to uphold the lower court decision. So they can do that, but the majority will write an opinion, and then those who are not in the majority can write dissenting opinions. And apparently, the dissenting opinions even disagreed with each other as to what they dissented to, and it does happen. So what Werner, the truck company, was fighting on appeal was a series of relevant facts that included several points damaging to the truckload carrier at the lower court level. Among those, there was black ice on the highway. Now, the driver of the Werner truck did not reduce his speed by an adequate amount to compensate for the weather. He was not allowed to operate a CB radio, which might have warned him from other drivers on the road about the conditions. Highway officers on the road saw this vehicle traveling at an unsafe speed given the conditions, and they estimated that to be 43 miles per hour, even as a local tow truck driver had slowed to 15 miles per hour, and that the injuries from striking the car driven by the other person would have been less calamitous if the Werner truck was operating at a slower speed. So they're saying, look, the accident was going to happen. If that truck had been driving slower, the accident wouldn't have been as bad. And now we're getting into the realm of almost like speculation. The lower court jury, in allocating blame, was asked to assign numerical values, put 70% of it on the owner of the truck, the trucking company, 14% on the truck driver, and only 16% on the driver of the vehicle that crossed the median. The trucking company's arguments on its liability came down to Texas law and how it holds an employer liable for actions taken by its employees. That question was the basis for one of the dissents submitted by a judge, but the full court was unsparing in agreeing that the trucking company was negligent in putting this driver on the road and how it managed him once he got there. He had been out of driver's school for not even 7 days. The risk was astonishingly high that a newly trained 18-wheel driver who is not trained to drive in winter weather would cause serious death or injury if confronted with a traffic scenario requiring quick reactions while traveling at approximately 50 miles per hour on a Texas highway with black ice, freezing rain, and freezing temperatures during a National Weather Service storm warning. And that's what the majority wrote in the opinion, noting that the driver had the second lowest possible evaluation score and was driving a high-pressure delivery or a just-in-time delivery. The end result, the judges wrote, is that Werner should have reasonably anticipated that it created unreasonable dangers for other travelers who were traveling in treacherous weather conditions. And that would even include travelers who are going to drive over the median and drive into you head first. Werner should have understood the foreseeability of its actions, the judges said. We do not believe it is too much to ask of Werner to require its drivers from driving unreasonably fast. In what it called a balancing analysis, the court laid out various tests. It said the possibility of risk, likelihood of injury, and foreseeability were all very high, given such facts as the weather, the high speed of the truck, and the driver's lack of experience. Offsetting those, partially, are the legal tests of magnitude of burden, the social utility of the actor's conduct, and the consequence of placing the burden on the defendant. All of them had been raised by Werner as defenses. And then balancing those factors, the judges said, imposes a duty on trucking companies to refrain from preventing their drivers from accessing information about dangerous weather conditions while they're driving, and refrain from assigning inexperienced or low-scoring drivers to high-pressure deliveries such as just-in-time runs. And this is a very tricky case. The reason I say that is that if you heard the facts of this case, you can see this case going either way. So if I simply told you that there's a truck driver, licensed and everything, driving down the road, and somebody crosses the median and slams into him head first, and those people in that vehicle are injured, whose fault is that? A lot of people hearing those facts would go, oh, it's obviously the fault of the people who crossed over the median and slammed into the truck driver. But then you say, well, on the other hand, there's all these other factors that play into it. the weather conditions, an inexperienced driver, and he may have been driving too fast for the conditions, although not speeding, et cetera, et cetera. You go through all that and you go, well, I guess I can see how somebody could say that's the truck driver's fault. And then you realize, well, you can also assign blame partially here and partially there, right? And then, of course, the real factor here is you've got a fatality, a quadriplegic injury, and other injuries to children. And suddenly you've got all bets are off. Because a jury very well could come in and go, we'd really like to compensate the victims who were so severely injured or those who died. And we want to do that. And of course, the trucking company appears to have deep pockets. So if there's money to be paid here, I guess it comes to the trucking company. And so I'm not saying there's anything right or wrong with any of that, because that's how our jury system works. But I think as a thought experiment, you could ask yourself this and realize that what I'm telling you is probably true. And that is that if you tried this case identically a dozen times, literally you conduct the exact same trial, word for word from opening statement to closing argument, but in front of a dozen different juries, you would get a dozen different results. And you would get juries who'd come in and go, the truck driver did nothing wrong. 0 is given to the plaintiffs. You'd also get people at the other end to go, oh, plaintiffs did nothing wrong. So make the trucking company and the truck driver pay boatloads of money. And you'd also get these things in the middle. And that's the problem, because on appeal, you have a hard time getting around the final conclusion of the jury when it comes to how they apportioned harm, for instance. They don't have to show their math. We have no idea how they did their math. All we know is they came up with 3 numbers that add up to 100. And that was 100% of the liability. But you will get radically different outcomes from different juries. And so I've had some people ask me about how important jury selection is. And people say, Steve, I heard that they use jury consultants sometimes. Does it really work? It turns out there are people out there, I'm not sure how much I believe in everything they say, but there are jury consultants who say, yeah, no, I can help you with jury selection, and we can get you a jury that's either more likely to go that way or more likely to go that way. And now suddenly you realize that when you're talking about hundreds of millions of dollars, if those kinds of calculations can be made to work, it would be worth it to put some money into that. So it's a tragic story all the way around, obviously. And so it's of great importance to a lot of people, including truckers. So this is out of Texas, and they say they're going to appeal this now to the Texas Supreme Court. The question is, what would be the grounds for the appeal? And so it sounds like that there's not a lot of complaints about the evidence that got in, although it may just not have come up here. But you're going to start getting looks at the bigger picture stuff. Does it really make sense that the person who crossed the center line and crossed the median on I-10 is only 16% liable for what happens to the vehicle that they are driving? That number might seem low. But again, I don't know if a Supreme Court of a state will step in and simply try to correct the math of a jury. So I will let you know what happens at the next level when that happens. But that's John Kingston writing for Yahoo Finance. Texas Appeals Court upholds a $100 million judgment against Werner Trucking. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. It is one thing to decide to climb a mountain, and it's quite another to be on top of it.